7 justices of the United States Supreme Court just issued an emergency ruling in the middle of the night, and it hit the American legal system like a sledgehammer through glass. A 7-2 emergency ruling. And if you have not heard about it yet, if this is not leading every broadcast and filling every front page, that tells you exactly what you need to know about the institutions that are supposed to keep you informed. This ruling, this single emergency order, just changed the fundamental architecture of how power flows in the United States of America. We are talking about the Supreme Court's 7-2 emergency ruling on nationwide injunctions, and it is one of the most consequential legal decisions in a generation. The establishment is scrambling. The media is hedging. The bureaucracy is quietly panicking, and the ordinary American deserves to understand every single word of what just happened, without the spin, without the softening, and without the corporate editorial filter that decides which truths you're allowed to process. So, let's get into it. If you are someone who refuses to let the most important legal and political developments in this country get buried under the daily noise, hit subscribe right now. Not because of some algorithm. Not for me. For yourself. Because this kind of constitutional moment gets swallowed fast by the 24-hour outrage machine, and you need a source that will not let it disappear. Subscribe and let's talk about what just happened. Here is something Washington has never wanted you to fully understand about nationwide injunctions. For decades, they were not a legal tool. They were a loaded weapon, and both political parties handled that weapon with the same reckless, shameless aggression. The game was simple, almost embarrassingly so. If your side lost in Congress, if the votes weren't there, if the democratic process delivered an outcome you didn't like, you did not go back to the voters. You did not build a broader coalition. You did not do the grinding, unglamorous work of persuading your fellow citizens. You found a federal judge, not just any federal judge, the right federal judge, sitting in the right city, in the right jurisdiction where you already knew how the wind blew. And then you filed your lawsuit, and you asked that one judge to issue a nationwide injunction. And think about what that actually means. One judge, one district court, one unelected jurist sitting in one corner of this enormous, complicated, diverse country. And with a single order, that judge could freeze a federal law, a presidential executive action, or a state policy across all 50 states affecting 330 million Americans without a single one of those Americans having any say in the matter whatsoever. That is not the American legal system functioning as designed. That is the American legal system being exploited systematically and deliberately by people who figured out how to win without governing. And for years, nobody with the authority to stop it actually stopped it. The scale of how normalized this became is genuinely staggering when you lay it out. Every major political fight you can name, from the last 2 decades, immigration crackdowns, environmental regulations, gun laws, voting rules, vaccine policies. In nearly every single one of those battles, at least one side ran to a federal court and got a nationwide injunction. It became the go-to play. It became so reflexive that legal teams at major advocacy organizations had it baked into their standard strategy. You lose in the legislature, you win in the courthouse. You lose at the ballot box. You find the right zip code with the right judge. And that is not democracy. That is a system where the accident of courthouse geography determines national outcomes. That is a system designed to be gamed, and it has been gamed without apology by the left, by the right, by corporations, by nonprofits, by federal agencies and state governments alike. The United States Supreme Court, in a 72 emergency ruling that crossed ideological lines in a way that demands serious attention, just declared that system constitutionally illegitimate. The court zeroed in on what legal scholars call scope of injunctive relief. In plain English, when a court sides with the people who brought a lawsuit, how far does that court's authority actually extend? Does it protect only the specific plaintiffs who sued? Or does it freeze an entire law, an entire federal policy for the entire country? The court's answer, delivered by 7 of its 9 justices, was as clear as it gets. Lower courts have been wildly unconstitutionally overstepping. Injunctive relief must be proportional to the actual injuries suffered by the actual people who brought the actual case. It cannot be weaponized to manufacture national policy outcomes through a judicial backdoor. That shortcut is over. Now, let's talk about what triggered this emergency ruling, because the context matters enormously, and the mainstream coverage is largely glossing over it. Multiple states, not fringe actors, not political outliers, but governors, Attorneys general and state legislators from across this country went to federal court to challenge what they described as a sustained pattern of federal overreach. They were not making small technical arguments. They were raising fundamental constitutional questions about whether federal agencies had been using emergency powers and executive orders to effectively rewrite law without any democratic mandate. Bypassing Congress, bypassing state legislators, imposing regulatory directives that nobody voted for and nobody had the real power to challenge through normal channels. These are not radical arguments. They are serious, well-grounded constitutional claims that legal scholars have been raising for years. States that were watching federal agencies expand their reach through regulatory action, that were watching executive orders reshape domestic policy in ways that would have required legislation a generation ago, finally said enough and went to court. And here is where this story becomes something close to infuriating. Because the lower federal courts, the district courts, and circuit courts that sit below the Supreme Court responded to these state challenges by doing the exact thing that 7 Supreme Court justices just called unconstitutional. They issued nationwide injunctions blocking state laws entirely before the cases were even fully argued, before the merits were adjudicated, before anyone had a real chance to be heard. Pause on that for a moment, because the audacity of it is breathtaking. States go to court saying the federal government is overstepping its constitutional boundaries, and the federal court system responds by freezing state laws nationwide. The fox guarding the henhouse does not even begin to describe it. The judiciary acting not as an independent check on federal power, but as an enforcement arm of federal executive authority. Lower courts reflexively, almost automatically reaching for the broadest possible remedy, national blocks, sweeping injunctions, policy-level outcomes in ways that went far beyond anything resembling a legitimate judicial remedy proportional to the dispute at hand. The Supreme Court saw it. They had seen it building for years. They had signaled their concern in earlier rulings, including Labrador versus Poe, where similar limits were discussed. But those signals were apparently not loud enough. The abuse continued. So, 7 justices did something they reserved for situations of genuine constitutional urgency. They issued an emergency order in the middle of the night, aligned across ideological differences, to put a hard stop to the practice. The message to every federal judge in this country was not subtle. The era of governing by injunction is finished. The era of one district court judge acting as a national policymaker is over. And if you issue a sweeping nationwide block without rigorous, specific, constitutionally grounded justification, the highest court in the land will reverse you fast. We are at the halfway point of this story, and it keeps getting more significant, not less. If you are watching this and thinking that this matters, that these institutional moments deserve serious attention from serious people, do something about that right now. Hit subscribe. Share this with someone who is paying attention to what is actually happening in this country in 2026, not just to the noise. And leave a comment below telling me which policy arena you think this changes most. We will get to all of them, but your voice in that conversation matters. Subscribe and share. Now let's talk about what the justices themselves actually said, because the language in this ruling is remarkable, and it deserves to be heard plainly. Justice Neil Gorsuch wrote a concurring opinion, meaning he agreed with the majority decision, but felt compelled to add his own separate reasoning. And a phrase he landed on is already being cited as one of the defining statements of this legal moment. He wrote that lower courts issuing these broad nationwide injunctions have been acting like mini legislators. Let that sit for a second. A sitting Supreme Court justice looked at the behavior of federal district courts across this country and said they are not functioning as judges. They are functioning as unelected lawmakers, accountable to no one imposing national policy based on a lawsuit brought by a small handful of plaintiffs in a single jurisdiction. Gorsuch went further, and his argument deserves to be taken seriously on its own terms. He argued that courts must return to what he called the traditional limits of equitable relief. The old established, long-standing legal principle that a court's remedy must be proportional to the injury actually suffered by the actual parties in the case. If you harm one person, a court can protect that person. You do not get to harm one person and have the judge ban your behavior toward 300 million people. That is not justice. That is policy. And policy in a constitutional democracy belongs to elected bodies, to Congress, to state legislatores, to the democratic process, not to federal courtrooms where nobody voted for anyone. Gorsuch is genuinely angry in this concurrence. Not performatively angry, not rhetorically angry for the cable news cycle, substantively, structurally angry about what has happened to the separation of powers in this country. He used this ruling as an opportunity to put that anger on the record in a way that future courts will be required to engage with. On the other side, Justice Sonia Soto, one of the two dissenters, raised concerns that are real and deserve honest engagement rather than dismissal. She warned that restricting nationwide injunctions could produce a genuinely chaotic legal. So, landscape. If courts can only protect the specific plantettes who sued, you end up with a patchwork reality where a law is enforceable in some states and blocked in others, where some Americans are protected by a ruling and others are not, depending entirely on whether they happen to be parties to a particular lawsuit filed in a particular courthouse. That is not a trivial concern. Unequal enforcement, inconsistent legal standards, rights that exist for some people in some places and not for others, based on geography and legal access. Those are serious consequences. But here's why the majority was not persuaded, and why even acknowledging the turbulence this creates, the majority got the fundamental call right. The alternative is not a solution to inequality. It is a different, more dangerous kind of inequality. It is a system where the accident of which court you file in and which judge you draw determines national outcomes for 330 million people. It is a system that has been shamelessly, relentlessly exploited by every well-funded interest group with a creative legal theory and a sympathetic jurisdiction on speed dial. The Supreme Court just said that system itself, the one Soyora is implicitly defending by warning about its absence, is the problem. If Congress needs to step up and build more consistent legal frameworks to prevent the chaos she is worried about, then Congress should do exactly that. That is what elected bodies exist to do. The answer to the failure of democratic institutions is not to hand their power permanently to unelected judges. It is to fix the democratic institutions. The consequences of this ruling will land in your life, in your neighborhood, in the policies that govern your daily existence. This is not abstract. Start with immigration. For years, immigration has been the most injunction-saturated policy arena in American law. The Trump administration's travel bans were frozen by nationwide injunctions. Biden-era immigration enforcement priorities were frozen by nationwide injunctions. Both sides used the same weapon, pointed it in opposite directions, and screamed about judicial overreach only when the other team was wielding it. Under the framework the Supreme Court just established, that back and forth becomes dramatically harder to execute. A state can no longer have its entire immigration enforcement apparatus frozen by a court order triggered by a lawsuit from plaintiffs in a completely different state with completely different circumstances. The borders of injunctive relief now match the borders of actual injury. That is a fundamental shift. Move to guns and understand the scale of what just changed. Multiple states passed significant gun regulations in recent years. Background check expansions, red flag laws, assault weapons restrictions, and multiple times those laws were hit with nationwide injunctions that froze them across the board before they ever had a real chance to operate. That dynamic is now substantially altered. A state that passes a gun law has significantly more runway to enforce. It's while legal challenges work their way through the courts, whether you support those laws or oppose them, understand that the mechanism for stopping them before they function has just been dramatically curtailed. That is a direct, immediate, concrete consequence for gun policy across America. And anyone who tells you it isn't is not paying attention. Elections may be the highest stakes arena of all. Election law has been drenched in nationwide injunctive warfare for over a decade. Voting rights challenges, voter ID laws, absentee ballot rules, redistricting fights. All of them at various points have involved one side running to federal court to get a broad national block. The Supreme Court's ruling makes it dramatically harder to use a single lawsuit in a single jurisdiction to freeze election rules nationwide. That means election policy, how you vote, who counts your vote, what your ballot looks like, is going to have to be fought in state legislatures and in Congress through the actual democratic processes the Constitution established, rather than won or lost by which side happened to reach the right federal judge first. That is a harder, messier, slower process. It is also the correct one. And then there is the environment where the stakes are arguably generational. Environmental regulations have been one of the most active arenas for injunctive warfare in American legal history. The Clean Power Plan, frozen methane rules, frozen water regulations, endangered species protections, all of them at various points subjected to nationwide injunctions, issued by district court judges. That tool just became dramatically less available. If you've been relying on federal courts to defend environmental protections that Congress will not pass through legislation, this ruling is a direct and serious blow to that strategy. The battleground just moved from courtrooms to legislatures. That is where it was always supposed to be. The political fallout from this ruling started the moment it was published, and it is only going to intensify. The White House and the Department of Justice both released statements that can only be described as carefully non-committal. Language about reviewing the court's order. Language designed to say nothing while sounding like something. That is the language of institutions that got hit hard and are calculating how to manage the damage without admitting its severity. Inside the DOJ, officials are privately using one word to describe this ruling earthquake, because that is exactly what it is. For an agency that has spent years using the federal court system as a policy enforcement mechanism, treating district court injunctions as a substitute for legislative action and democratic mandate. Meanwhile, state attorneys general moved with a speed that tells you they were ready for this moment. Within hours of the ruling coming down, AGs from multiple states had already filed supplemental legal briefs in ongoing cases, citing the Supreme Court decision as direct authority for their arguments against federal overreach. Legal teams that had clearly been watching and waiting for exactly this kind of ruling deployed it the instant it arrived, arguing that the court had affirmed what they had been saying all along, that states retain the right to defend their sovereignty without being subjected to blanket injunctions from federal judges, substituting their policy preferences for democratic processes. And here is the political dimension that nobody in the mainstream media is being fully honest about. This ruling does not help one party. This ruling does not advantage one ideology. In this particular political moment in 2026, with the current configuration of power in Washington, the states most energized by this decision tend to be red states fighting federal policies. But the dynamic is not fixed. It flips entirely depending on who holds the White House. When Democrats controlled the executive branch, it was red state attorneys general using nationwide injunctions to freeze progressive federal policies. When Republicans control the executive branch, it was blue state attorneys general using the exact same tool to freeze conservative federal policies. Both sides screamed about judicial overreach when the other team held the gavel. Both sides celebrated it when their team did. The Supreme Court just looked at all of them and said, "Stop, you want to make policy for this country? Win elections, pass legislation, build democratic coalitions, persuade your fellow citizens, go through the process that the Constitution actually established. You do not get to manufacture a national policy outcome by filing a lawsuit in the right zip code with the right judge. That era is over. So where does this go from here? What is the road ahead, actually?" So the first thing to understand is that this was an emergency ruling, not a final comprehensive opinion on every question it raises. The door is not closed. The argument is not finished. The case goes back to lower courts, which will now have to apply this new, narrower framework to the actual disputes at hand, and they will do so under intense scrutiny, knowing that the Supreme Court is watching and that issuing a sweeping nationwide injunction without rigorous justification is going to get reversed fast. The federal government will push back. It will identify cases where it can argue that the national interest is so compelling, the constitutional stake so fundamental, that broader relief is justified even under the new framework. There will be test cases, appeals, circuit court splits, where different appellate courts interpret the new standard differently, and those splits will eventually force the Supreme Court back to weigh in again with a full merits decision. This is the beginning of a long legal recalibration, not the end of the fight. But what will not go back to the way it was is the Supreme Court's public declaration issued formally on the record with a 72 supermajority that the practice of using nationwide injunctions as a political shortcut is constitutionally illegitimate. That declaration carries enormous weight. It changes how lawyers advise clients. It changes how advocacy organizations structure their legal strategies. It changes how federal agencies calculate risk when they issue new rules. It changes how states think about their legal exposure when they pass controversial legislation. The entire calculus of American legal strategy just shifted, and no amount of political spin changes that fact. There is a deeper implication to this ruling that deserves to be said plainly and without softening. For years, for decades, both political parties have quietly been happy to let the federal judiciary accumulate power was never constitutionally intended to have because it was convenient, because it meant you could win without governing. You could achieve national policy outcomes without winning Congress, without winning state legislatures, without doing the exhausting, unglamorous work of building democratic coalitions, and actually persuading your fellow citizens that your ideas were right. You could just find the right judge. The Supreme Court just slammed that door. And what that means, whether you love this ruling or you fear it, is that American democracy is about to be forced to function more like an actual democracy. And if you want change, you have to win elections. You have to pass laws. You have to govern. The courts cannot be a substitute for political legitimacy. A favorable injunction is not a mandate. A sympathetic judge is not a democratic consensus. That is a harder system. It is messier. It will produce outcomes that frustrate people on every side of every debate. It will require more patience, more organizing, more actual civic engagement from citizens who have been allowed to outsource their political responsibilities to lawyers in federal courtrooms for far too long. But it is the system the Constitution actually created. And 7 justices of the Supreme Court just used one of the most powerful tools at their disposal to push this country back toward it. This is what a constitutional moment looks like. Not a headline, not a tweet, not a partisan talking point that your preferred cable network spins into a 2-minute segment before moving on to the next outrage. This is a structural shift in how power operates in America, decided by a court that saw a genuine abuse and acted with urgency to stop it. The breadth of the coalition, 7 justices crossing ideological lines, agreeing that this particular practice had gone too far and done real damage to the constitutional order, should force every serious person to sit with what just happened. This is not a team sport moment. This is a constitutional moment, and constitutional moments do not wait for convenient news cycles. The question that remains, the question that will define the next chapter of American legal history, is whether the political branches will respond to this responsibly. Will Congress build clearer, more consistent legal framework so the absence of nationwide injunctions does not produce the chaos justice stoned about? Will state legislatures engage more seriously with the constitutional limits of what they can legislate? Will federal agencies become more disciplined about how they issue rules and enforcement actions, knowing they can no longer count on a friendly district court to freeze anything that pushes back? Or will everyone spend the next decade searching for new shortcuts, new workarounds, new ways to game a system that 7 justices just told them to stop gaming? The Supreme Court can draw a line. It cannot make anyone respect it. And that part, that critical, decisive part, is up to the rest of us. The voters, the citizens, the people who actually elect the politicians who appoint the judges, who write the rules that govern all our lives. The court just reminded us that self-government is supposed to be hard, that democracy is supposed to require work, and that you do not get to outsource your political failures to a federal judge and call it justice. That reminder, issued by 7 justices in the middle of the night as an emergency order, is one of the most consequential legal and political acts of 2026. It will be taught in law schools. It will be cited in courtrooms for decades. It will be felt in legislatures, in elections, in the daily policy decisions that shape American life in ways most people never think about until something in their world suddenly changes. This 72 emergency ruling is a turning point, a real one. Not a partisan turning point, a constitutional turning point. Whether it becomes a genuine lasting correction to decades of judicial overreach, or whether it becomes just another ruling that gets slowly eroded by creative lawyering and institutional resistance, depends entirely on what happens next in Congress, in state legislatures, in federal agencies, and in the choices made by millions of ordinary Americans who are paying attention or not paying attention to the structures that govern their lives. You stayed with this. You are paying attention. That matters more than you know, because the conversation this country needs to have honest, informed, unafraid starts with citizens who refuse to let the most important developments get buried under the noise. Do something with what you now know. Subscribe so you do not miss the next major shift. Share this with someone who deserves to understand what is actually happening in America right now. And leave a comment telling me which policy area, immigration, guns, elections, the environment, you think this ruling hits hardest. Let's have a conversation. This moment demands. I will see you in the next